This is People versus Pablo Forenza, 23T125. Mr. Forenza appears in custody. Mr. McCall is here for the people. Give me 1 second, I'm joining WebEx. I'm trying to. Mr. Forenza refused to stand before the entry.
I can't stand. I'm shackled like a criminal. Over.
What you're about to watch is a perfect storm of arrogance, misunderstanding of the law, and consequences hitting like a freight train. This isn't just another courtroom clip. This is what happens when someone believes they've outsmarted the entire legal system, and then reality shows up with handcuffs. Our main character here tried to play a very common but very flawed game, rejecting the authority of the court altogether. Instead of defending himself, presenting evidence, or even participating in his own trial, he walked out. Just left. As if the rules simply didn't apply to him. Now here's the twist. The legal system doesn't just shrug and move on. Judges have tools, very real tools, to deal with a behavior like that. And one of those tools is contempt of court. It's not about the original charge anymore. It's about respect for the process itself. So now, months later, he's back, but not by choice. He's in custody, facing a judge who remembers exactly what happened. And what unfolds next is equal parts frustrating, fascinating, and honestly inevitable.
Your Honor.
Well, I'm going to give you that opportunity. I'm going to advise you if you'd like it. Let me start by reading the relevant portions of the contempt rule, Mr. Forenza. This is Rule 407. This is of the rules of civil procedure, but that same rule applies to criminal actions such as this one. I'll read the relevant sections. Subsection A1, disorderly or disruptive behavior, a breach of the peace, boisterous conduct, or violent disturbance toward the court, or conduct that unreasonably interrupts the due course of judicial proceedings, behavior that obstructs the administration of justice, disobedience or resistance by any person to or interference with any lawful writ, process, or order of the court, or any other act or omission designated as contempt by the statutes of these rules. This will be direct contempt, and I will cover that in a second, but the rule is direct contempt is contempt that the court has seen or heard and is so extreme that no warning is necessary, or that has been repeated despite the court's warning to desist. Subsection 4 defines punitive sanctions for contempt, which includes punishment by an unconditional fine, fixed sentence of imprisonment, or both, for a conduct that is found to be offensive to the authority and dignity of the court. Most notably is subsection B, as in boy, which says addresses direct contempt proceedings. When a direct contempt is committed, it may be punished summarily. In such case, an order shall be made on the record in writing reciting the facts constituting that contempt, including a description of the person's conduct, a finding that the conduct was so extreme as that no warning was necessary, or the person's conduct was repeated after the court's warning to desist, and a finding that the conduct is offensive to the authority and dignity of the court. Prior to the imposition of sanctions, the person shall have the right to make a statement in mitigation. Mr. Forenza, I'm going to offer you that opportunity in a little bit. I make a specific finding that all conduct that I'm referencing occurred in my presence and therefore is direct contempt. Very specifically, let me make some reference. Mr. Forenza has been disrespectful to the court, to opposing counsel, and even to my clerks throughout the proceeding. He has filed spurious documents. He's made nonsensical arguments. He's been argumentative with the court, but I was willing to let all of that go so we could try the matter. On the day of trial, which I believe is November 24th, Mr. Forenza appeared on time, but stayed in the gallery along with who I believe is his wife. I repeatedly, at least 3 times, but perhaps 4 or 5, told him to approach the court, to cross the bar and sit at table so we could address the trial. Mr. Forenza failed to do so in my direct presence. He told me I had no jurisdiction.
Here, in just a few seconds, we see the core misunderstanding that drives this entire situation. He believes, genuinely, that this is all about a traffic citation. In his mind, he's being treated unfairly for something minor. But the judge immediately corrects that narrative, and it's a crucial distinction. This is no longer about speeding, licensing, or any basic infraction. The moment he walked out of his own trial, he shifted the entire situation into something much more serious. Contempt of court is about defying the authority of the judicial system itself. Might it's not a fine, it can mean jail time. And what makes this moment so telling is that he doesn't seem to grasp that shift. He's still arguing from the wrong battlefield. While he's focused on the original issue, the court has already moved on to something far more significant.
Forenza was under an order to perform, that is to come to the table. He refused to perform in accordance with that order, and even though he had the ability to perform, obviously he was mobile, he was able to make it into the courtroom and then, of course, make it out. He was repeatedly warned, and I note that. I gave him multiple opportunities to approach, and he disregarded all of them. I make a specific finding that I find Mr. Forenza's conduct to be offensive to the authority and dignity of the court. I make a specific finding that he engaged in misbehavior that rises to the level of obstruction of justice. The behavior happened in my presence. The conduct was intentional and willful, and these actions seriously affronted and disrupted the administration of justice. In that regard, I will note that I went and met with the 30 or so jurors who had appeared for the trial that Mr. Forenza simply blew off. I had to explain why that happened, and I had to waste all of their time. I also wasted the time of the witnesses. Mr. Forenza, I didn't waste anybody. Mr. Forenza also wasted the time not only of the jurors, but of the witnesses, counsel, the court. And
Legal jargon. But what the judge is doing here is extremely important and very deliberate. He's building a record. Every definition, every subsection, every clarification is being stated out loud, so there's no ambiguity about what's happening or why. This isn't just for the defendant, it's for the appellate court, for the record, and frankly, for accountability. If this decision is ever challenged, everything the judge is doing right now shows that the process was followed correctly and transparently. Notice also how the judge emphasizes direct contempt. That's key. This means the behavior happened right in front of the court. No investigation needed, no witnesses required. The judge saw it, heard it, and is empowered to act immediately. In other words, this isn't a gray area. From the court's perspective, the facts are already established. What remains is deciding how serious the consequences should be.
everyone else, the court finds him in direct contempt. I made a similar record on the morning of trial, but Mr. Forenza had bolted from the courtroom, and therefore I find he was not advised at that time, so at least not in any significant way, and I hereby advise him. I am considering a jail term for the contempt unrelated to the underlying charges, Mr. Forenza. I'm going to offer you some opportunities of how you want to proceed. First, if you wish, you can make the statement of mitigation right now, if you wish to. If you do not wish to, if you wish to consult with counsel, I will give you time to hire your own counsel, but you will remain in custody during the interim. I would even be open to the appointment of counsel if you believe you are indigent. In fact, I would appoint counsel if you were indigent. How would you like to proceed? And if you'd like a few moments to think about that, I'm fine with that.
Is that the only option is how I like to proceed, or can I make a statement?
Right, so I'm offering you option one and options 2 and 2A. Option 2A and 2B. Option 1 is you can make your statement of mitigation right now, right? And without counsel, the only person in the room other than court staff and the deputy is Mr. McCall. We are live streaming. You can make that. If you'd prefer, you can contact an attorney, and I will set this over for a time.
It's where the judge lays out a pattern, and that's critical. This isn't about one bad decision on one day. It's about repeated behavior over time. Disrespect, nonsensical filings, refusal to cooperate. These things build a narrative, and courts pay very close attention to patterns. I nod because a single mistake might get leniency. But consistent defiance? That signals intent. It tells the judge this wasn't confusion or stress. It was a conscious choice to disrupt the process. Also notice how the judge mentions giving multiple opportunities. That's huge. Courts are generally patient, especially with self-represented individuals. But patience has limits. And once those limits are crossed, consequences become...
If you are indigent, the actual language is in a Supreme Court guidance, which says Colorado, I'll just read it to you. Colorado Rules of Civil Procedure 107 and 407 provide for the appointment of counsel to an indigent person cited for contempt where a jail sentence is contemplated. I am contemplating a jail sentence, Mr. Forenza. If the court appoints private counsel to prosecute a contempt action, which is not applicable here, or to represent an indigent party for contempt charges, that is relevant here, the judicial department will pay for counsel, as there is no statutory authority for the public defender or alternate defense counsel to represent clients for the sole purpose of contempt. But to qualify, you would have to be indigent, which means you would fit below the guidelines for public defender representation. If you wish, I can print those guidelines out for you.
Don't want to be represented.
I'm sorry, I couldn't hear.
I don't want to be represented.
Okay, and you understand that, and I will allow you to make the statement of mitigation right now, but you understand you do have a right to counsel.
The only way to look at it is I never got a fair trial walking into this. He failed to prove jurisdiction, sworn affidavit. The courts failed, personal, subject, territorial. I moved it to federal. I even had documents which I sent. It was ignored. Everything gets ignored. I'm just, you know what? I guess I'll just let you beat me up, throw me in jail, get it over with, because you can't keep me the rest of my life. And then, I'll deal with the consequences and things later. I mean, that's where I'm at.
Okay.
It's not right over a traffic citation where all I did is I came here in good faith to resolve the matter. And it was just, I could get nothing. There's no nature and cause of there. There's no sworn affidavit for me to even move forward on. And this court can't move forward on. That's all I asked for. And it was like retaliatory. I just got beat up. That's all this is. It's a traffic citation. It's not a crime. Nobody was injured. If that's, if that's what you call justice and fair, I'm not here to sit here and pick at anybody, go after, and that's not what it's about. When I posted bond for whatever it was, I came here and I didn't run. I came here to settle the matter. And that's all I wanted to do. And I just wanted a fair trial. That's it. But you get in my shoes, and how does it feel when you're just getting beat up and the judge...
That often gets overlooked, but it's actually one of the most serious aspects of the entire situation. The impact on everyone else. Courtrooms don't operate in a vacuum. There are jurors who took time off work, witnesses who prepared to testify, attorneys who built their cases, and court staff coordinating everything behind the scenes. When someone just doesn't show up, or worse, walks out, it doesn't just inconvenience the system. It wastes real time, real resources, and real money. And judges take that very personally because they're responsible for managing that system efficiently. That's why the judge is emphasizing this point so strongly. It's not about ego, it's about disruption of justice. The system depends on participation. When someone refuses to engage,
this trial, we actually brought the officer from across the state, met with him on the weekend beforehand to prepare for the trial. Officer Carnes was kindly enough, like I said, to drive on his own accord and his own expense to be here. He said he would come back for a retrial. He would request to be flown back, just given the type of the weather that it would be probably when it would be done. The people are still open to a plea agreement in this case for the traffic citations. We understand Mr. Forenza's stance as a sovereign citizen of what law he feels applies, but Your Honor, we believe that the traffic laws of Colorado apply in this case. We are more than willing to negotiate a plea agreement to this day. But at this point, Your Honor, that's where the people are, Your Honor. We didn't anticipate any jail in this case. We didn't anticipate anything but to paying the penalties for speeding 25 to 39 over on the Riverside Parkway back in 2023. And the failure license. Your Honor, the speeding ticket, I would even reduce it to 20 to 24 over to keep it in it as a traffic infraction.
On the contempt.
On the contempt. Oh, on the contempt, Your Honor. Your Honor, it's been an interesting case for me. I've never had a case that have gone this long. with kind of like you know, the lack of being able to move forward. I've never been personally federally attempted to be sued in any case based upon a fee schedule. It finds it interesting that Mr. Forenza believes that contract law applies in this case, but only one way, his contract law. The issue here, Your Honor, on contempt, the people expended a lot of time on this case for a very minor case. I do not like putting someone in jail in this situation. I just don't know if Mr. Forenza will ever show up to a trial again in this case, for this case, or any case. He's done, what, a day or so in jail?
I'm not, anything else you want to say?
No, Your Honor, the people are, that's all the people are going to say.
Mr. Friends, I meant to ask Mr. McCall to make that statement before your statement. I forgot. If you'd like to make a statement to address anything he said, I'm happy to hear more.
Yes, I mean, I just objecting. I did, like I said, I came in good faith to settle the matter. And
Trying to reframe the narrative again. Back to fairness, back to good faith, back to feeling wronged. And on a human level, that can sound compelling. Everyone wants to feel heard. Everyone wants to believe they're being treated fairly. But legally, even this argument is completely missing the mark. The judge even points it out. If you believe the court is biased, there are proper channels: appeals, motions, legal arguments. Walking out is not one of them. What's happening here is a clash between personal belief and legal procedure. The defendant is relying on how he feels the system should work, while the court is operating on how it actually works. And those two things...
saying it's contract, and that makes it a commercial matter, so I'm here to settle the matter. Set off and discharge, and, you know, as a secured party creditor, I have a right to do that. An attorney, in fact, representing the estate. So I would like to do that. Let's settle the matter. Let's just wash.
I'll give you an opportunity to resolve the matter, but we're talking about the contempt right now. I view the contempt as your direct and unequivocal disregard of the court's order. What would you like to say in mitigation of that?
Your Honor, it's not, like I said before, it has nothing to do with that. I wanted to settle the matter, and I feel like I'm running in circles, nowhere to turn, but who do I have to turn to? I'm trying to get this resolved, you know, coming into court and hoping in good faith that you do the right thing, and it just didn't seem like it was going that way. And I've never gotten any response to anything I've ever submitted. And that's what makes it hard. So how do you react to that? I mean, what do you do? Me, my situation, I'm scared. Okay, well, I have, you know, look at, I mean, torture cuffs and sitting here over a traffic citation.
Adds another layer to the story: effort. Real, tangible effort that went into preparing this case. An officer traveling across the state, meetings over the weekend, coordination just to be ready for trial. All of that reinforces how seriously the system was taking what started as a minor offense. And that contrast is striking. On one side, you have preparation, you need professionalism, and willingness to resolve the matter, even offering plea deals. On the other side, you have refusal to participate and claims that the system itself is invalid. The prosecutor even makes it clear, jail time was never the goal here. This could have been resolved quickly, cheaply, and easily. But because of the defendant's choices, it escalated into something far more common.
I find that Mr. Forenza, I don't know about negotiations. That's not my area of, not my area. But I find he has not litigated this in good faith. I find that he absolutely and unequivocally disregarded a repeated order of the court to come to the table on the morning of his trial. The remedy Mr. Forenza had would be to have the people try to prove their case beyond a reasonable doubt. He absolutely positively refused the court's order, despite repeated statements. It follows up a long history of disrespect from Mr. Forenza towards the court, and more specifically, the entire judicial system. I find there to be no good faith by Mr. Forenza. I am not addressing the underlying case. I do note that there's a new speedy trial date in that case. That new speedy trial date is July 8th, 2026. I thought about rescheduling the trial today. but I'm not going to do that. I'll do that at Mr. Ferenz's next appearance. As to the contempt itself, and this is only as to the contempt, I note the difficulty. My plan was coming in to give 30 days jail, given Mr. Ferenz's statement of indicating of the difficulty this has caused him. I'll reduce that a little bit, but not much. This case, I hereby sentence Mr. For direct contempt. I sentence Mr. Ferenz to 25 days in jail. Furthermore, I set this matter for hearing on my next in custody docket I'll put him, though it's going to be a busy day, it doesn't make a lot of difference. Today's the 8th. Yeah, I want to set him in the next round. I'll set him on the front.
Everything has been building toward 25 days in jail, not for speeding, not for paperwork, but for contempt of court, for refusing to participate, for walking out, and for repeatedly disregarding the authority of the court. What makes this outcome so significant is how avoidable it was. This started as a minor traffic issue, something that, in most cases, is resolved with a fine or a brief appearance. But through a series of decisions rooted in defiance rather than strategy, it escalated into actual jail time. The judge made it clear this wasn't about punishing beliefs, it was about enforcing order. Courts rely on participation, structure, and respect for the process. Without that, the entire system breaks down. So the real takeaway here isn't just about this one case, it's about consequences. Actions in a courtroom matter, choices matter, and ignoring the system doesn't make it go away, it makes it come back stronger.